Hey everyone, welcome back to the channel. It's excellent to have you here as always, and thank you for watching. Quick reminder to check your subscription status and all the things associated with it. Many of you have confirmed over the last several days that your stuff has indeed been messed with without your knowledge. Just because you are seeing this video doesn't mean that it hasn't been screwed with. Make sure that it is set up the way that you would like it to be. Today, we're going to be covering some updates in the CRS Firearms case, also known as the auto keycard case involving Matthew Hoover. And this thing has been reported on ad nauseum at this point in time across the internet, so I don't need to rehash the individual details of the case and how we got to where we are today. And if you need to read yourself in, there's a full chronology of that information available through various outlets on the interwebs. To make sure that we are playing with the same deck, though, most of the reporting that we get on the case comes from John Crump over at AmmoLand. And it is no secret, and John has made it no secret, that he is a close associate of Matthew Hoover, and thus he has a personal interest in the case. And it would be remiss if we did not mention that. But also, John is a professional freelance Second Amendment reporter, and he's doing his job while also serving his personal interest in the case, right? Now that we have defined the intrinsic biases associated with any of the information that I'm about to share with you, the development is that the gun owners of America have intervened in the case on behalf of John Crump, the journalist, on First Amendment grounds. Because what has occurred, apparently, is that the prosecutor has decided that it is in their best interest to suppress particular documents that John Crump has legally obtained as material to report to the public pertaining to the case. MEC respectfully moved this honorable court for leave to file an amicus brief, a copy of which is attached hereto in support of John Crump's emergency motion to intervene for limited purposes of responding to the United States motion for order prohibiting dissemination of pre-sentence investigation report. What's going on here is that the U.S. attorney alleges that because John is not part of some established media consortium, like the big ones that you would be able to name off the top of your head, that he does not have a valid claim to be able to report on any of the issues associated with the case. And the gun owners of America argue that that is just simply not the case. The freedom of the press is integral to the functioning of our democracy and is a foundational tenet of our system of government because it allows the people to hold the government accountable. In this case, the government seeks to silence the press and avoid accountability by discounting the legitimacy of members of the press on the implied premise that because they are not associated with any mainstream, air quotes, or legacy, air quotes, news network, they are not a legitimate member of the press. The government seeks to diminish the status of freelance reporters who self-publish their content by referring to them pejoratively as YouTube personalities. It is firmly established that the First Amendment's aegis extends further than the text prescription on laws abridging the freedom of speech or of the press, and encompasses a range of conduct related to the gathering and dissemination of information. Indeed, freedom of speech and the press are two of the great bulwarks of liberty, and therefore shall never be restrained, but every person shall be held responsible for their abuse. Every person may speak, write, and publish sentiments on all subjects, but shall be responsible for the abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. Moreover, changes in technology and society have made the lines between private citizens and journalists exceedingly difficult to draw. The proliferation of electronic devices with video recording capabilities means that many of our images of current events come from bystanders with ready cell phone or digital camera rather than a traditional film crew. And news stories are now just as likely to be broken by a blogger at a computer as a reporter at a major newspaper. Such developments make clear why the news gathering protections of the First Amendment cannot turn on professional credentials or status. John Crump is a professional journalist. It is of no significance that Mr. Crump also publishes his content on YouTube or his own website. Because we, the people, are the press, there is no requirement that he possess press credentials from the New York Times in order to be considered a legitimate news outlet. He is a journalist who has a constitutional right to report on these events. The following individuals are independent journalists who have joined together and who, like John Crump, are engaged in the essential task of gathering and dissemination of information on various topics of importance to the public. Each of them reports on issues related to the Second Amendment and the right to bear arms, and have an army of viewers who rely upon them to ferret out government impropriety. So signed the attorneys of record and the following amici: Eric Blanford, Paul Glasgow, Jared Yanis, Hank Strange, Patrick James, Tim Harmsen, Clint Morgan, John Mullally, Micah Young, John Correra, Mark Davis, Kenneth Graham, Scott Wilson, and yours truly. In closing today, the First and Second Amendments are integrally intertwined. You can't have one without the other. And it is imperative that we stand and fight whenever we are given the opportunity to defend any of the God-given inalienable rights that are enshrined in our Constitution, because we cannot give them an inch or they will take a mile.